What lies behind the evidence? Confidentiality is a seemingly difficult task in maintaining a client's privacy while still fulfilling legal obligations. Information shall only be utilized in relations to the greater good of the investigation. Information regarding a case or investigation shall only be discussed with individuals who are directly involved with or participating in the case or investigation. This could be members of the prosecution team, the defense team, or the judge over the case. Confidentiality maintains the integrity of the investigation and protects individuals from retribution. In relations to confidentiality, there is also privilege, which is the legal protection limiting what information is allowed to be shared in a court setting. State-specific, certain professional or personal relationships can obtain privilege protection via a court proceeding by exempting certain communications from disclosure. Attorney-client privilege is a legal doctrine that protects the confidentiality of communications between a client and their attorney. Work product privilege protects all documentation prepared by an attorney in the anticipation of litigation. Spousal communication privilege applies to both civil and criminal cases and protects the private communication among spouses during a valid marriage. Privilege against self-incrimination, any evidence either intentionally or unintentionally provided that suggests personal involvement in a crime is guarded by the Fifth Amendment, as no person can be forced to testify against themselves in criminal casings. Examples of breaching confidentiality include someone publicly comments on matters still pending in court, accessing confidential information without the need to know, and leaving confidential information either unattended or unsecured. A strong example showing how important confidentiality is to the world of forensics is the Golden State Killer case. Law enforcement unknowingly obtained his DNA from a car door handle that he discarded and matched it with the distant relative's DNA that was publicly uploaded to a genetic history website, which was GED Match. This DNA is only really protected by the terms of service from the companies that you decide to upload your DNA to. All the DNA company has to do is list that there may be other uses for this provided information, which can include law enforcement usage. It is common for participants of these websites to not even read the terms of conditions, and if they are read, they are likely to not be fully understood. But regardless, this is something that still falls back onto the user of the website. There are very limited DNA laws when it comes to online DNA databases and legal practices. Most of the time, people do not even consider the possibility of law enforcement agencies using this public information. The law has not yet caught up to the information we have available within our digital society. This relates back to ethics, as some may say that this process was ethically wrong because an individual might not even know their relative voluntarily gave their DNA. But is it really ethically wrong or a stab at privacy if it led to something good, like convicting the Golden State Killer? There is a notable difference between pleading insanity and pleading incompetent. The insanity defense and competency to stand trial are often confused. The insanity defense is a legal strategy arguing that the defendant cannot be held responsible for their actions even if these actions were criminal, as they were not mentally capable of realizing the wrongfulness at the time that they were committing the crime. Competent enough to stand trial focuses on the defendant's ability to understand the charges, understand what will happen during the trial, and understand their rights. If they are not competent enough to stand trial, the criminal proceedings are postponed while professionals treat the defendant until they are competent, and then the trial will resume. Competence and ethics are intertwined in a variety of forensic fields. When a defendant declares incompetence, it raises important ethical considerations relating to their rights, to the justice process, and the role of mental health in relation to legal proceedings. Right to a fair trial. Ethically, defendants must be competent to stand trial, meaning that they should understand the charges against them and should also be able to participate in their defense. Declaring incompetent protects this fundamental right, ensuring that individuals are not subjected to legal processes that they cannot comprehend. Protection from harm. If a defendant is genuinely unable to understand the legal proceedings due to mental illness or cognitive impairment, ethical principles dictate that they should not be held accountable in the same way as a competent individual would. If a defendant is truly declared incompetent, no matter how strong the evidence of guilt is, they cannot be convicted normally. Instead, the state may pursue civil commitment, which is the involuntary placement into a psychiatric hospital for treatment. Is civil commitment ethical? Some argue yes, as when relating to the law and the criminal actions of the defendant, this is intended to help them through the form of rehabilitation, as well as not pose a risk upon society if the defendant were to be released too soon. Some argue no, as civil commitment is the most serious deprivation of individual liberty that a society may impose, raising another question on if they cannot understand a trial, how can they understand why they are sent to a mental institution? Due process is the legal process that protects individual rights by ensuring that the government follows already established rules and laws when people's rights are in question. The ethical obligation to ensure due process requires that any claims of incompetence should thoroughly be evaluated. This involves proper assessments by qualified professionals, ensuring that the defendant's rights are being upheld. Some tests to prove competency or prove insanity include the M'Naughton test, the irresistible impulse test, and the substantial capacity test. The M'Naughton test declares that all defendants are to be presumed sane unless they can prove that at the time of committing the criminal act, the defendant's state of mind caused them to either not know what they were doing when they committed said act, or that they knew what they were doing but did not know that it was wrong. The irresistible impulse test determines one's ability to control their behaviors to avoid committing illegal acts. Relating to this test is the idea of volitional incapacity, which is the inability to control behavior and avoid committing acts that you know are wrong. The substantial capacity test, unlike the M'Naughton test and the irresistible impulse test, looks beyond simply knowing right from wrong and beyond controllable actions, as it considers whether the defendant's mental illness significantly impaired their ability to understand the wrongfulness of their actions or to control their behavior. The varying testimony given in a court proceeding can be generalized into three separate categories. These categories include eyewitnesses, expert witnesses, and character witnesses. Eyewitnesses are to describe exactly what they saw or who they saw. Expert witnesses are specialists who testify regarding their area of expertise. Character witnesses are people who know the defendant involved in the case. The main form of false or uncertain accounts or recollection stem from two of the three areas of court testimony, one of these being the eyewitness testimony and the other being the expert witness testimony. Wrongful convictions can be the result of two main components: eyewitness misidentification and witness perjury. Eyewitness misidentification relates to the human memory that can oftentimes be highly fragile and misleading in its attempt to fill in gaps. In high-intensity situations, the brain is less accurate in making an identification. What happens is the brain only identifies similarities, and the jury is unlikely to reject someone's testimony who is there to be a valid eyewitness. Witness perjury relates to when a witness intentionally lies on stand because they will receive a benefit from testifying against the defendant. It is important to note that unintentionally misidentifying in itself is not unethical, though it can lead to unethical outcomes for the defendant or be caused by unethical methods of practice. One of these practices is the production of a photo lineup by law enforcement. For an administrated photo lineup to be ethically acceptable to all parties, they must align with the following. Filler selection. A minimum of 6 different photos with characteristics such as race, height, age, gender, facial features, and clothing should be similar to those of the suspect based on the witness's description. They should avoid using mugshot photos or any photos that have any identifiable markers. Presentation methods. Simultaneous versus sequential. Instead of simultaneously showing all photos at once, consider using a sequential lineup where photos are shown one at a time, as this can reduce false identifications. Double-blind procedure. The official administrating the lineup should not know which photo the suspect is, as this can lead to intentional or unintentional suggestion of some sort. Witness instructions. Inform the witness that the perpetrator may not even be in the lineup, as this minimizes the feeling of being pressured to point someone out, especially if the witness is not completely certain. Further considerations. Multiple witnesses. If you have multiple witnesses, the lineup should be presented to each separately to avoid contamination of identification. Appearance consistency. Ensure all photos in the lineup are of a similar quality, size, and color contrast as to not be seen as any given suggestion against a specific photo. Suspect placement. If multiple lineups are utilized and presented to a witness, you should randomize the placement of the suspect photo to strengthen the identification claim. An unethical expert testimony can be conducted on the basis of a variety of different aspects, some of which begin before the expert even takes the stand to those that happen while testifying. Providing outright false data. The legal system relies on truthful evidence and testimony to function effectively. False data undermines the integrity of the justice process and erodes public trust in the system. Altering data, resulting all the original documentation to the most effective way of discovering alterations that can consist of changes to data or documents that are not supported by analysis. Proper corrections require that a single line be drawn through the mistake with the recorded author's initials and date of change. Anything short of that is suggested of document tampering, which is unethical. Reaching conclusions before research is conducted or completed. An expert witness is intended to strictly provide specialized knowledge to help the court and jury understand complex issues in a legal case that they may not have previous knowledge on. An expert witness is not intended to draw conclusions from the evidence, nor are they to express their opinions in any matters towards the case, as this could influence the jury's decision. Going outside of their area of expertise. It is not uncommon for the other side to ask an expert witness a question that falls outside of their prime area of knowledge. The proper response to a question that does not align with the area of knowledge that they are there to talk about is simply saying that is outside of my area of expertise. It is unethical for an expert witness to try to draw an explanation on matters in which they are not confident in, nor that they have had proper education on. An expert witness speaking outside of their area of expertise can lead to a multitude of further complications within the courtroom. A trial by ambush is a surprise twist in court where one side is caught off guard by an unexpected witness or piece of evidence presented. This puts the opposing side at a disadvantage because they do not have time to prepare a defense or to prepare a cross-examination. To prevent trial by ambush, both sides in a trial engage in a formal process called discovery. During discovery, the parties exchange information about the witnesses and the evidence that they plan to present during trial. This allows both sides to know what is expected before the trial even begins. One of the most common methods of discovery is to take depositions. A deposition is an out-of-court statement given under oath by any person planning to be involved in the case. It is to be used at trial or in the preparation for trial, and both the defense and the prosecution have the right to be present during oral depositions. Depositions enable a party to know in advance what a witness will say at trial so they can properly build their case. Often, a witness's deposition will be taken by the opposing side and used to potentially discredit the witness's testimony during trial if the trial testimony does not match with the testimony taken during the deposition. This creates a fair trial and a fair chance for both parties involved. The overall goal of the legal system is to discover the truth and seek justice for those involved, no matter whose favor that may be in. Trial by ambush undermines this system, as withholding information can lead to delays and complications in court, as well as unjust outcomes for either the victim or the defendant, as such surprises during a trial can ultimately waste judicial resources.